This is called contract. So there is a contract between customer and the bank. So this is called relationship between bank and customer. If customer want to take loan, this is called contract between bank and customer. So that's why we have to learn this particular act, because there is a connection between this act and the bank. Is that okay? So now the contract act is basically divided into two parts. The first part is general principle of contract. The second part is special principle of contract. It means the contract law book is bifurcated into the two part. General principle of contract, first of all, no need to learn this part, no need to learn this part. Whatever section I will say you now that this section is important, only that section you have to learn. So contract is basically divided into two parts. So in 2 days we will cover general principle of contract. In 3 days we will cover special principle of contract. Okay, so total in 5 days we will complete Indian Contract Act. So this come into force in the first day of September 1872. It's applied to the whole of India. Is that okay? Now, C class 1 to 75 General Principle of Contract. 76 to 123 section is missing in this part. And contract contain total 266 section. So now after 238 there is a no section. It means 239 to 266, this is the particular part. So these two parts have been removed from the Indian Contract Act, and now these two parts become a particular act. The first is Partnership Act, the second portion is Sales of Good Act. So from the Indian contract, this question can be asked in your exam because these two acts we have to study in module D. These two acts are the part of module D. So that's why you have to understand from where this act come into picture. So this act, these two acts has been removed from the Indian Contract Act. If I will say you 76 to 123 portion has been removed from the Indian contract and it's become the SOGA Act, that is Sales of Good Act. And 239 to 266 has been removed and it's come into the Indian Partnership Act. That's it. So this is the basic thing about Indian Contract Act. Now I will give you a best example to understand the formula of contract, because class in the general principle of contract now I will teach you only the formula of the contract. Okay, only formula of the contract I will teach you in the general principle of contract. Okay, now the first one. See, offer. I'm giving you one example. Suppose X person just go for the shopping. Okay. Now X person want what I say black sari, right? So X person is offering to the shopkeeper. So shopkeeper have accepted that okay sir, we will give you the black sari. So when offer come into acceptance, when offer become acceptance, it become promise. Promise in legal term, in law term, it's called agreement. See, offer plus acceptance is equal to promise. Promise in legal term is called, law term is called, it's agreement. So now class, agreement is various type. Agreement can be social agreement. Agreement can be domestic agreement, religious agreement, and legal agreement. I will give you example of all the agreement. Okay, now see, social agreement example. Mummy is offering you breakfast and you are not accepting. So class, tell me, can mummy file case on you? Mummy is offering breakfast and you are not accepting. Can mummy will file case on you in the court? Say yes or no. Say yes or no. Yes, Sharda ma'am, Shagun ma'am. Social means that is related to the society, so the answer is no, mummy will not file the case. Domestic, same, husband wife. Sanjay sir, husband is saying that I will give you a necklace in the evening, but in the evening husband not give necklace to the wife. So can wife file the case on husband? wife can file the case on husband that you have not fulfilled your offer? The answer will be no. Excellent. No. Religious agreement. Suppose if I promise to Ayodhya temple that I will give you 10 lakh rupees in the construction of Ayodhya Mandir, but I didn't give. So nobody can file the case. So what we have to understand? So we have to study legal agreement. Legal agreement means that X person have deposit the money and the shopkeeper have given the black sari. So in the legal agreement, both party are getting something. Both party are getting something. So this rupees and this black sari is called consideration. So always remember, in legal agreement, in legal agreement class, okay, in legal agreement, this is called consideration. So consideration is not in social, in domestic, in religious, but in legal agreement, consideration must be from both sides. So for X, rupees is consideration. For shopkeeper, sorry, the black sari is consideration. Okay, so in the legal agreement, when the law will enforce, what is law enforceability? Tell me, class. Suppose if X have paid the money, but the shopkeeper is not giving sari. So what X will give? Tell me. Suppose X person have paid rupees for the sari, but the shopkeeper is not giving. So what X will do? What X will do? Tell me. Tell me what X will do. Shopkeeper is not giving sari to the X person. Now what X can do? This is very simple. Exactly, Sanjay sir. X can file the case on shopkeeper. So law enforceability means in which any party can file the case. So law enforceability will be always in legal agreement. Always. Okay? Law enforceability will be always in the legal agreement. Is that okay? So guys, we have to study what? Offer plus acceptance is equal to agreement. That agreement should be legal agreement. In legal agreement, when law will enforce, it means any party have right to file the suit. This is called contract. So this is the best example of or best formula of contract that you have to remember. So Shagun ma'am, you can just imagine all the example of contract. In all the example, this formula is fit. Suppose you people have taken the paid class, right, Shagun ma'am? You have given the price for the paid batch. Okay. But ma'am, Adda is not giving you class. So what you will do? Adda is not giving you class. So what you will do? Tell me. Exactly. So you will file the case. You will file the case. Absolutely right. So this is called contract. So I think this formula is clear to all of you. Any doubt in this formula? Any doubt in this formula? Because now I'm going to just explain this formula in the next slide. Okay, ma'am and sir, because this formula is very important. The general principle of contract is totally based on this formula. That's it. And this formula is not written in your book. So I have just made this formula. So that will make you easy in learn the contract terms. Okay. Now see, the person who is making offer, that is called proposal. The person who is accepting the offer, that is called acceptance. Promise, when offer is accepted, become promise. Promiser, the person who is making proposal. Nikita ma'am is suppose offering car. Nikita ma'am is promiser, and to whom I am giving car, that person is called promisee. So this is called definition term, Ganesh sir. And in each act, you have to remember the definition also. Because from definition portion, I think 5 to 8 questions come from the definition portion. So this is called definition portion. So the statement will be there in your exam and the four options will be there. Four words will be there. You have to tick mark that which definition belong to this sentence. And I will give you, C class, suppose one act will be complete. When the Indian Contract Act will be complete, ma'am and sir, I will give you the questions of Contract Act. I will give you the definition terms of Contract Act so that it will be very easy for you to remember each act. Okay, so this is the formula. Now see, contract. So I think contract when agreement enforceable by law. A very short formula. See, contract is equal to agreement plus enforceability by law. And what is agreement? We have already learned offer plus acceptance. That is called agreement. Offer plus acceptance, that is called agreement. Okay, now see, all agreement are contract. All agreement means not social, not religious, not domestic. Then all agreement are contract when free consent of the party. Free consent means suppose if two persons are doing contract, they have to enter into contract freely. We should not pressure anyone that you have to do this contract. If we are pressuring now, it is called not a valid contract because section 10 talks about valid contract. Section 10 talks about class the valid contract. This is very important. Section 10 talks about the valid contract. Is that okay? Okay, valid contract. So the first point of valid contract, the party must be, when enter into contract, they should be free consent. Competent to contract. Competent means a 10-year person cannot enter into contract. Exactly, Shagun ma'am. I will explain each point in the next slide. Okay, because what I have told you, general principle of contract is totally based on the formula. So I'm going to explain the terms of the formula in the next to next slide. Okay, so this section 10 is very important because this section 10 talks about the valid contract. Section 10 talks about the valid contract. That's it. Okay, now lawful consideration. Consideration, I have already told you, something for something, it should be lawful. Suppose if I'm giving you drugs and I'm making contract, this is not called lawful consideration. Lawful object, every contract have a lawful object. Okay, lawful object means suppose you have taken the paid batch, your motive is to crack CAIIB. So this is the object of your contract. And contract should not be void. Void means that cannot enforce in front of the court. Contract should be valid. It should not void. Is that okay? Now class, you have to tell me and explain me this sentence. All contracts are agreement, but all agreement are not necessarily contract. What do you mean by this term? A very simple sentence. Apply your common sense. You can easily give me the reply. All contract are agreement, but all agreement are not necessary contract. Shagun ma'am, exactly. Some agreement which are not enforceable by law is not a contract. It is not a contract. Shagun ma'am, just correct your sentence. Yes, exactly, Shagun ma'am. Good. Honey class, I have already explained agreement may be broken. Okay. After agreement, it become contract. Excellent. Excellent. Now see, I will explain this formula. All contracts are agreement. Why class? Because we know the formula of contract now. When offer become acceptance is equal to agreement plus law enforceability is equal to contract. So if I'm saying contract, so contract comes in this formula. So all contracts are agreement, yes. But all agreement means social agreement, religious agreement, and legal agreement. all agreement are not contract. So we know that social agreement cannot be contract, religious agreement cannot be contract, only legal agreement can become the contract. That's it. Exactly, Sanjay sir. So this is the meaning of this sentence. Now it is clear, guys. Now it is clear or not? Okay, that's cool. That's cool. Okay, that's cool. Now, class. Now I'm going to explain you, the formula, whatever we have discussed in the point wise form. Okay, so what is this essential point of a contract? So now we are just going to study the essential points of valid contract. Okay, essential points of valid contract we have to study. Okay, now see, the first point is what? There must be at least two party in a contract. Yes, we know that. In any contract, one person cannot do contract by himself. So for contract, at least two parties should be there. The first party should be called offerer and second is called offeree. If Nikita ma'am want to sell her car, Nikita ma'am is offerer and I want to sell my car to the Akshita ma'am. So Akshita ma'am, you are offeree. Offerer is also called promiser. Offeree is also called promisee. That's it. So this is your first point. Second point, there must be offer in a contract, we know. So offer must be clear, defined, communicated to the offeree. What it means? Tell me, class, if I say to the shopkeeper, give me 100 liter of oil. Tell me, class, this offer is clear or not? I just went to the shop and I say, give me 100 liter of oil. So my offer is clear or not? Tell me, my offer is clear or not? Okay, not. So what I have to say? What I have to say? What I have to say, Arvind sir, to the shopkeeper so that my offer will be clear? Exactly, BK sir. I have to say, sir, give me 100 liter of parachute oil. Now my offer is clear. Now my offer is clear. So offer must be clear, defined, communicated to the offeree. Offeree means shopkeeper. That's it. And acceptance. There must be acceptance. Acceptance must be absolute and unconditional. Suppose if Nikita ma'am want to sell her car to the Akshita ma'am. So Nikita ma'am is offerer and Akshita ma'am you are offeree. So Akshita ma'am, you will not put condition to me because car is mine. I can decide, I have to decide the price of the car. So the condition will be put by me, not by you. So acceptance must be unconditional. And what is absolute? It is my choice. Okay. Suppose if I say you, Akshita ma'am, that Akshita ma'am, you have to give me reply through mail. So Akshita ma'am, you have to give me reply through the mail because I will put condition. You cannot put condition. So acceptance must be absolute, unconditional. This is your second point. And now, invitation to offer is not equal to offer. So, guys, these are the two terms. Invitation to offer is different, offer is different. What is invitation to offer? See, in the shop class, in some days, sale, 90% sale, 95% sale, these are what? Invitation to offer. Exactly, Shagun ma'am. Okay, exactly. Done. So invitation to offer means suppose if a shopkeeper have just in the dummy just paste 90% sale, 100% sale. So actually the shopkeeper is inviting. The shopkeeper is inviting to please come in our shop and just purchase the thing. So this is called invitation to offer. So shopkeeper is inviting. Suppose if I select black sari. So now I will go to the shop. I will say that give me black sari. Now after invitation to offer, the offer will come, then acceptance will come, then the formula will come. So you can say class, the invitation to offer is before offer. So invitation to offer is totally different from offer. Suppose if I just want to auction my house. If I just want to auction my house, this is called invitation to offer. So invitation to offer is different from offer. That's it. Okay? So these are the example that you have to study. Done class? Done? Next one. Proper offer, proper acceptance with intention to create legal relationship. It means class, in any contract, there must be legal relationship between the two person or the parties of the contract. You people have taken the paid batch. There is a legal relationship between us. Why? Because suppose if Adda is not giving you the classes, you can file the case. This is called legal. Okay, this is the very best example, Balfour versus Balfour. As we know that in our exam, case studies questions come. So this is called case studies question. In the case studies question, the fact will be given and one question will be there. So you have to understand the fact, you have to just analyze the concept, then you have to give the answer. So in the Balfour versus Balfour class, husband wife is there. They just go for tour. In that tour, wife got injured. She just got admitted in the hospital. So in the hospital, doctors say that wife cannot move from the hospital because she is really very bad injured. But husband have to go to the his place because he want to do his job continue. So husband say to the wife that I will give you 20,000 rupees per month as a this one rupees to you. Okay, so husband have given 20,000 rupees for 3 months, but in fourth month, husband stop making payment to the wife. Now tell me, in this case, can wife file the case on husband? Tell me, in this case, can wife file the case on husband? Tell me. In this case, what do you think, GK sir, that there is a legal relationship between husband and wife or not? In this particular case, there is a legal relationship between husband and wife or not? Tell me. The answer is no. In husband wife, I think in husband wife, there are so many promises made between them. So many promises, Vinodidhi ma'am. If one person is not fulfilling the promise, so other party cannot file the case. Other party cannot file the case. But in the same example, if I say you, there is a divorce case between husband and wife. Okay, there is a divorce case between husband and wife. Court order husband that you have to pay 50,000 rupees to your wife, and husband stop payment to the wife. Can wife file the case on husband? Tell me. In this case, can wife file the case on husband if husband stop giving maintenance to the wife? Excellent. Excellent. This is called contract. So in the maintenance case, there is a legal relationship between husband and wife, but in normal promises, there is a no legal relationship between them. Exactly, Shagun ma'am. It's a court order. It's a court order, so that's why it's a legal contract between husband and wife. Husband have to pay maintenance. It is a legal duty of husband to pay maintenance to the wife. That's it, ma'am. Okay? Is that okay, class? Done? So this is a very famous case. Now, the next point is mutual consent. There's a one legal word that is consensus ad idem. What is consensus ad idem? Same thing in the same sense. One example I'm giving you. Suppose class, if Nikita ma'am, okay, ma'am, our court out of scope contract, ma'am, but But ma'am, our court order outside the scope of no, 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 Shagun ma'am. Suppose Shagun ma'am, if two persons are doing contract, one person have breached the contract. Breach means violate the rules and regulations of contract. So ma'am, we can file the case on court. We can file the case to the court because there is a breach of contract. So court interference must require in the breach of contract. Shagun ma'am. Okay, that's it. So class, one example for 4 point. Nikita ma'am want to sell black car, but Shagun ma'am want to take red car of Nikita ma'am. So tell me class, is Nikita's ma'am thinking or Shagun ma'am thinking are same? Nikita's ma'am thinking and Shagun ma'am thinking are same. Tell me yes or no. The answer is no. Exactly. The answer is no. Good. Okay, the answer is no. So that's why class in every contract there should be consensus ad idem means same thing in the same sense. Same thing means red car and we both have to think red car. So in a valid contract there must be mutual consent of the parties. That's it. Okay, now contract must be free and genuine consent. Okay, suppose X and Y are doing contract. Coercion means threaten. Undue influence means to hypnotize. Fraud means to deceive. Misrepresentation means wrong presentation, and mistake means mistake. Suppose class, if X person threaten Y that give me your property in the name of X, otherwise I will shoot you. So Y have given his property in the name of X. So in this particular case, the contract is done, the contract is made, but this is not a free consent contract. So in this case class, Y have a right to breach the contract. Y have a right to breach the contract. So Y will file the case. Y have to prove that X have threatened me. If Y will prove, the contract will be end. Hypnotize, Y is hypnotizing Y. X is hypnotizing Y. Fraud, X is doing fraud with Y. X is doing misrepresentation with Y. So in all the cases, only Y have a right to breach the contract. This is called that every contract must be done in the free consent. Okay, and class, always remember, when only one party have right to breach the contract, this is called voidable contract. This is called voidable contract when only one party have right to breach the contract. So in this case, only Y have a right to breach the contract. This is called voidable contract. Hanji class, tell me, is that clear or not? Is that clear or not? Tell me. Nanda Gopal sir, there is a no WhatsApp group of BRBL. Okay, if you want to join BRBL, there is a Telegram group, CAIIB 2024. Okay, Shagun ma'am, sure. Voidable contract again. Okay, ma'am, see. Suppose, ma'am, X person is saying, I have a two property, A and B. But actual X have only one property, that is a B. X want to sell both property to the Y person. Okay. But as we know that this A property not belong to X. So it means X is doing fraud, right? And for both the property, Y had given 2 crore rupees. So the contract is done between X and Y. But when Y know that X is making fool, so in that case, Y will file the case on the court and the court will decide that this is fraud or not. So in that case, Y have only right to breach the contract, to end the contract. So this is called voidable contract. So voidable means when only one party have right to breach the contract. This is called voidable contract. So the contract which is made between X and Y regarding this property, this contract is called voidable. Tell me class, is that clear? Shagun ma'am? Is that clear? Okay. Done. This is called voidable contract. So ma'am, if X person have done coercion, if X person have done undue influence, if X person have done fraud, if X person have done misrepresentation, if X person have done mistake, so in that case the contract is made between both the party, but opposite party have right to end the contract. This is called voidable contract. So right now we have done valid contract. Right now we have done voidable contract. That's it. Okay. Now see this example of forge, this example of undue influence. Okay. I will give you the one example of undue influence. Suppose Nikita ma'am is a very famous Baba. You know what is Baba? Ganesh sir come to me. Ganesh sir is saying, Nikita ma'am, I just want to clear CIB exam in a first and single attempt. Nikita ma'am hypnotized Ganesh sir and she is saying, Ganesh sir, you have to give me all your property in the name of Nikita ma'am, then you can easily crack your exam. And Ganesh sir on that time is on unconscious mind. So Ganesh sir given all the property in the name of Nikita ma'am. In that case, the contract is done between me and Ganesh sir, but that contract is not made with the free consent. Why? Because Nikita ma'am hypnotized Ganesh sir. So Ganesh sir, you have a right to end the contract. This is called the contract which is done by undue influence. Is that clear? Tell me, is that clear? Done? Done, class? I think the 5 points are clear to all of you. Just revise what we have done. There must be two parties. There must be offer, acceptance. There must be legal relationship between party. There must be mutual consent and there must be free consent between the parties of the contract. So what we are doing, ma'am and sir, we are doing just the formula of contract. That what are the things required for the valid contract. That's it. Okay, now next point. Performance must not be impossible. Okay. Um, Ganesh sir, if I say you, bring me star, I will give you 1 crore rupees. So we have just make a agreement. Is that possible? Guys, is that possible? Tell me. Is that possible that Ganesh sir can bring star for me? Tell me, tell me. We have done the contract, Ganesh sir, in which we have written, Ganesh sir, please bring me a star. I will give you 10 lakh rupees or 1 crore rupees. Is that possible? The answer is no. So, guys, the contract must be possible. So, performance must not be impossible. Performance must not be impossible. Okay, then agreement must be certain, that is clear, oral, written, not vague, indefinite. Not vague means same. Star example. Star means bring me star, I will give you 1 crore rupees. This cannot become a contract. The agreement will be what? Void. So this is the certain qualities of agreement. Agreement means before contract. Okay, tell me class, there is a oral contract, there is a written contract. Which contract will prevail? Tell me. There is a oral contract, there is a written contract. So which contract will prevail over what? Tell me, tell me. Exactly, Ganesh sir. Tell me, class, there is a written contract, there is a oral contract. Which contract will prevail? The court will believe on which contract? Excellent, Ganesh sir. Anyone? The court will always take in the written contract, because written contract we can represent as an evidence in front of the court. Exactly. Okay. Now, parties must be competent to contract. You can see we are just doing the formula. Parties must be competent. Competent means party must be major. Major means plus 18 year. Sound mind. Sound mind means we all people are sound mind. It means we can understand what is right, what is wrong, and not disqualified by law. It means, suppose class, a convict person is there. Convict person means the person who is in the jail. So tell me, BK sir, if a person is in the jail, can he do contract? If a person is in the jail and if he want to sell his land, it can be possible. It can be possible. The answer is no. So that's why if any person is doing contract, that person must not be disqualified by law. See, convict person disqualified by law. Foreign sovereign, it means the person under the government, if he is coming, if he want to do any contract, so he have to take permission from the government. So foreign sovereign cannot do contract, diplomatic staff cannot do contract easily. They have to take permission. Okay. Now, one of the famous case, that is Mohari Bibi versus Dharmodas Ghosh case. This case is very, very much important. Now see, X is a minor person. Okay, X is a minor. He want 20 lakh rupees from Y. But Y do not know that X is a minor. And in that case, X have given immovable property as a security to the Y person. Now, when Y get to know that X is a minor, he want to end the contract. So now tell me, class, is this contract that is between X and Y, that is a valid contract? X is a minor. Minor means below 18. The answer will be no. The answer will be, class, no. Is that okay? The answer will be no. Okay, so X cannot be the what? He is a minor, he cannot enter into the agreement. So if a minor is doing any contract, first of all, the contract will not happen. This is called void agreement. It means because before contract agreement come, so that agreement is called void. Void means which do not have any existence in front of the law. If lunatic person, lunatic means a mad person, if he is doing contract, that is called void agreement. And person disqualified by law, this is called void agreement. This is called void agreement. That's it. Is that okay? So minor cannot do contract. Lunatic person, lunatic means a mad person, cannot do contract, and person disqualified by law cannot do contract. If they make any contract, first of all, contract will not happen. The agreement will be void. So void means which have no existence in front of the law. So class, in this case, the court held that this is void agreement between X and Y, and Y cannot take his 20 lakh rupees. In this case, the court held that Y cannot take his 20 lakh rupees. That's it. So this is the crux of your case. This is the crux of your case. Is that okay? This is the crux of your cake. Done? See, the court held that agreement made by minor is void ab initio. Again, this is a legal language. Void ab initio means void from the beginning. void from the beginning. From the starting, if any minor is doing contract, that will be the void from the beginning. And no question of refunding the money. Okay. So class, if any case studies question will come, so in the case studies question, the fact will be there and four options will be there. So that's why you have to at least understand and learn the cases of this particular act. Tell me class, any doubt right now? Any doubt? Try to understand each concept. After that, when I will give you the questions, you can easily do that question of each particular act. Okay? Is that okay? Any doubt, class? Any doubt? Yes, Vinodini ma'am, Vinodhini. Ganesh sir. Ganesh sir, when I will say you that you have to learn that section, only learn that section. That's it. Okay? I have to put the sections in the presentation because that is written in the book. So whenever I will tell you that this section is important, you have to understand, learn that section. Exactly, Shagun ma'am. Shagun ma'am, if we are doing contract with a minor for the benefit of the minor, na, that is valid. That is a very deep point that is not written in your syllabus. But you have asked the question, I have given you the answer. Okay? If any contract is done with the minor for the benefit of the minor, that is a called valid contract. Okay? That we have learned in the LLB course, ma'am. That we have learned in the LLB course. Okay? Now, class. Next. See. As we know that for every contract, the person must be sound mind. Sound mind means the person capable of understanding and forming a rational judgment. Exactly, that is called sound mind. We all are sound mind person. That's why we can do any contract. Okay, now see. First point, second point. A person who is usually unsound mind, usually means suppose in 24-hour, 23-hour, that person is a mad. But for 1 hour, the person becomes sound mind. So in 1 hour, when the person becomes sound mind class, he can make a contract. This is your first point. This is the first point. Shweta ma'am, yes. Second point, the person usually sound mind, just like us. But occasionally, for 1 hour, any person can become unsound. So when that person become unsound, he cannot make a contract. The conclusion is that only sound person can do the contract. That's it. So this is very important point. Is that okay, class? Is that okay or not? Tell me. Done? Try to understand each concept very thoroughly. Is that okay? Any doubt till now? So I think for today, that is sufficient. Rest of all, we will do it tomorrow. Okay? And Shweta ma'am, the question of your answer is yes. For the benefit of lunatic person also, if we are doing contract, the contract will be valid. Okay, ma'am? So guys, today we have learned a lot of things. Now see, it's a quick revision. First of all, Indian contract is divided into two parts, journal and spatial. 2 days we have to study the general principle of contract. Two acts have been removed from the Indian Contract Act. The act name is Partnership and Sales of Good Act. This is the formula of contract. This is the definition term of the contract. This is the definition of contract. Okay. Section 10. Now class, you have to learn section 10. Section 10, which talks about the valid contract. That's it. Valid contract, section 10. And these are the explanation of section 10. Two parties, offer acceptance, legal relationship, mutual consent, free and genuine consent, person must be competent to contract. That's it. So from that slide, we will study it tomorrow. Okay, guys? So all the best. Done. And please join the Telegram. It's a BRBL CIB 2024. It's my Telegram group name. If you want to join, you can join the class. Okay? Thank you so much. And do not forget to give the feedback when I will just close the session. Okay? Bye-bye.